Subcommittee on Government Operations and National Security will come to order without objection. The presiding member is authorized to declare recess at any time. Mr. Meadows is not here yet. He does have an opening statement. I think he's on his way, so if he wants to give it, we'll obviously do that. I'm second seat here, so I don't have one. So what I'll do is I'll recognize the ranking member. Mr. Conley's not coming, right?
I know he's around, but I know we got a lot going on this morning.
Okay, so I'll recognize the ranking member on my subcommittee, Mr. Lynch, and I'll let him do his opening statement.
Thank you very much, Mr. Chairman. I appreciate the courtesy. I want to thank you for holding this hearing, and I also want to thank the witnesses for helping us with our work. This hearing is to examine the anti-consumer fraud efforts undertaken by the Federal Trade Commission following the end of Operation Chokepoint. I'd also like to thank all of the staff on both sides for preparing this hearing. The Consumer Protection Branch at the Department of Justice initiated the investigative and enforcement program known as Operation Chokepoint in November of 2012. This operation examined efforts of fraudulent practices perpetrated through the U.S. banking system against bank customers by unscrupulous merchants, financial institutions, and intermediaries referred to as third-party payment processors. As reported by the Department of Justice, fraudulent online merchants would typically unlawfully direct their payment processors to initiate debit transactions against consumer accounts and transmit the money back to them. In the most egregious cases, the payment processors had full knowledge that merchant clients were committing those fraudulent transactions and illegally siphoned money from customer accounts anyway, as some banks simply looked the other way. In furtherance of Operation Chokepoint, the Department of Justice issued 60 administrative subpoenas from February 2013 through August 2013 to entities that it believed had evidence pertaining to consumer fraud schemes. One of the most recent settlements that arose out of this operation occurred in March of 2015 when the Department of Justice announced that it had reached a $4.9 million settlement with Commerce West Bank of California. The civil complaint in the case alleged that the bank had ignored a series of red flags and facilitated consumer fraud by permitting Las Vegas payment processors to make millions of dollars in unauthorized withdrawals from consumer bank accounts on behalf of fraudulent merchants. The warning signs included an extremely high rate of rejected debit transactions that were returned by customers and their banks, as well as inquiries that Commerce West received from other financial institutions about suspicious illegal activity involving its payment processor. I understand that some members of Congress expressed concern that the Department of Justice, in cooperation with the financial regulators, such as the Federal Deposit Insurance Corporation, was unlawfully targeting certain categories of legitimately operating businesses. In response, the House Financial Services Committee, the House Judiciary Committee, and this committee all conducted extensive investigations of Operation Chokepoint, beginning back in the 113th Congress. In December of last year, the House also passed H.R. 2706, the Financial Institution Consumer Protection Act, by a bipartisan vote of 395 to 2. I voted in favor of this legislation, which seeks to address concerns stemming from the facts surrounding Operation Chokepoint by prohibiting the FDIC and other financial regulators from terminating their relationship with specific customers without a valid and written justification. As underscored in a letter to Congress sent by the Department of Justice in August of 2017, quote, all of the Department's bank investigations conducted as part of Operation Chokepoint are now over. The initiative is no longer in effect, and it will not be undertaken again, close quote. It is my understanding that the purpose of today's hearing is to examine whether Operation Chokepoint has nevertheless continued at the Federal Trade Commission, despite its official termination. I greatly appreciate the willingness of our witnesses to testify on this topic today. However, as ranking member of the Subcommittee on National Security, it's my sincere hope that during the remainder of the 115th Congress, we will work together on a bipartisan basis to conduct meaningful oversight on those issues that are most pressing to the safety and security of the American people, our dedicated military and civilian personnel deployed overseas, and our returning veterans. It simply does not serve the interest of national security when the Principal Oversight Committee in the House has held more hearings on shark finning, believe it or not, shark finning, and red snapper fishing in the Gulf of Mexico than it has on the ongoing civil war in Syria. Can you believe that? Which is now entering its 8th year. We currently have more than 2,000 American troops deployed in a destabilized country that just witnessed a massive offensive undertaken by the forces of Syrian President Bashar al-Assad to recapture the southwestern city of Dara. The operation caused catastrophic damage to the city and displaced more than 300,000 Syrians to the Syrian-Jordanian border and the Golan Heights frontier. And just yesterday, Islamic State militants launched a series of coordinated suicide bombings across Sweda in southern Syria, killing more than 200 people. So this committee has not held a single hearing on our national security policy towards North Korea either. This issue demands robust oversight following the Statement of Principles on Nuclear Nonproliferation signed by President Trump and North Korean President Kim Jong-un at their Singapore summit in June, and the initiation of diplomatic talks led by Secretary Pompeo. We have held 0 hearings on the state of our counterterrorism operations in Africa, believe it or not. Our American Green Berets, U.S. Navy SEALs, and other commandos are currently on the ground in Africa under so-called Section 127E Special Ops Authority. These units are undertaking perilous counterterrorism raids with African partner forces in Nigeria, Somalia, Libya, Tunisia, Kenya, and other nations, and their safety necessitates rigorous oversight by this Subcommittee on National Security. And, of course, our ongoing military and counterterrorism operation in Iraq and Afghanistan, where we still have an estimated 6,000 and 15,000 American troops deployed, respectively. That should command our regular attention. While Iraqi Prime Minister Haider al-Abadi declared final victory over the Islamic State last December, the terrorist group is reemerging across Kirkuk, Diyala, and Salahuddin provinces through a wave of insurgent attacks and kidnapping. The security environment in Afghanistan also continues to deteriorate. This week alone, a suicide bomber carried out an attack near Kabul airport, killing 14 and wounding more than 50 individuals. Early this morning, a Taliban suicide bomber attacked a security convoy of the Afghan National Intelligence Agency. So, Mr. Chairman, I respectfully request that we begin to work on those issues and conduct oversight of those issues and other critical national security issues going forward. And with that, I will yield the balance of my time. Thank you.
Gentleman yields back. I'm pleased to introduce the witnesses. We have Mr. Andrew Smith, the Director of the Bureau of Consumer Protection at the FTC, Jason Oxman, Chief Executive Officer at the Electronic Transactions Association, and Ms. Lauren Saunders, Associate Director of National Consumer Law Center. Welcome to you all. Pursuant to committee rules, all witnesses will be sworn in before they testify. So if you guys can please stand and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? All right, please be seated. All witnesses answered in the affirmative. In order to allow time for discussion, please limit your testimony to 5 minutes. Your entire written statement will be made part of the record. As a reminder, the clock in front of you shows the remaining time during your opening statement. The light will turn yellow when you have 30 seconds left and red when your time is up. Please also remember to press the button to turn your microphone on before speaking. And with that, Mr. Smith, you're recognized.
Thank you, Mr. Chairman and Ranking Member Lynch. My name is Andrew Smith, and I'm the Director of the Bureau of Consumer Protection at the Federal Trade Commission. My written statement submitted for the record represents the views of the Commission, but this opening statement represents my views alone and not necessarily the views of the Commission or of any individual commissioner. The FTC is the nation's primary consumer protection agency. We are a bipartisan and independent agency governed by 5 commissioners, and we're dedicated to pursuing law enforcement actions to stop unlawful practices, including fraud against consumers. In the last 10 years alone, the FTC has brought more than 600 cases in federal court against companies and individuals who engage in unfair and deceptive conduct, including countless cases challenging fraudulent telemarketers and online scammers. The FTC has returned hundreds of millions of dollars to American consumers while obtaining strong injunctive relief to protect consumers going forward. When we bring a case against a fraudster, we routinely look for others who knowingly facilitated the fraud, whether it be a telemarketing boiler room, a robocalling platform, a lead generator, or a payment processor who actively participated in the fraudulent scheme. In only 15 of these hundreds of fraud cases that we have brought since 2008, in only 15 of these cases have we seen fit to bring an enforcement action against a culpable payment processor. And these 15 instances weren't the product of the FTC staff acting on its own whim. The bipartisan commission, both Republicans and Democrats, approved each of these matters by a unanimous and a public vote. As these numbers demonstrate, the FTC doesn't take action against payment processors lightly, and the 15 cases that we have brought were not even remotely close calls. In each case, we had specific evidence that these payment processors were knowingly facilitating the misconduct of their merchants by actively evading the anti-fraud protections of the national payment system. For example, we've sued payment processors who have opened multiple, sometimes hundreds, of dummy merchant accounts to hide fraudulent transactions, dilute consumer complaints and chargebacks, and subvert the critical systems established by banks and the card networks to monitor for illegal activity. We also have seen payment processors that deliberately lie to banks and the payment networks about the line of business of their merchants, as well as payment processors engaging with merchants in a high volume of sham payment transactions to paper over the real but fraudulent transactions that resulted in consumer chargebacks. And I should note that the frauds perpetrated by the merchants in these 15 cases were of the most egregious sort, causing hundreds of millions of dollars of injury to consumers, causing hundreds of millions of dollars of injury to consumers. These constituted sham business opportunities, credit card interest rate reduction scams, fraudulent online discount clubs in which consumers never enrolled, and grandparent scams harming older Americans. The FTC doesn't intend to impose on payment processors the responsibility to police their customers, but we do expect payment processors to follow the well-established rules of their industry, and they must abide by the law. So when we see evidence that a payment processor is knowingly facilitating a fraudulent scheme, we will not hesitate to act to protect consumers. As the law enforcement numbers show, this isn't a game of gotcha for us at the FTC. We sue payment processors sparingly and only where we have powerful evidence of their complicity in the underlying fraud. Thank you for the opportunity to testify. I welcome your questions.
I thank the gentleman. Mr. Oxman, you're up for 5 minutes.
Thank you, Mr. Chairman. I'm here representing ETA, the Electronic Transactions Association. We're the trade association for the payments industry, representing over 500 companies that offer electronic transaction processing products and services to merchants. ETA supports the enforcement of existing laws and regulations by federal agencies, including the Federal Trade Commission, to stop fraud. But what we're deeply troubled about is the FTC's use of Operation Chokepoint-style tactics to hold payment processors responsible for fraud committed by bad merchants. The Department of Justice ended Operation Chokepoint in 2017 following congressional scrutiny and criticism. That scrutiny demonstrated that holding payment processors liable for merchant fraud has serious adverse consequences, including processors abandoning lawful categories of merchants disfavored by the government, as well as higher prices for consumers. Now again, the payments industry is dedicated to fighting fraud and ensuring that consumers have access to safe, convenient, and affordable payment services. Consumers choose electronic payments, indeed, because they have zero liability for fraud. ETA has worked hard as an industry representative to develop guidelines on merchant and ISO underwriting and risk monitoring. These guidelines provide more than 100 pages of best practices to detect and halt fraudulent actors. ETA has shared these draft guidelines with the Federal Trade Commission, which has encouraged us to strengthen anti-fraud efforts. The FTC's targeting of the payments industry actually predates Operation Chokepoint and indeed exceeded the Department of Justice's efforts in scope, but somehow has managed to fly under the radar until today. Many of our member companies receive what are called civil investigative demands, CIDs, from the FTC, asking for dozens of categories of information about dozens of different merchants. Many of our payment processor members receive multiple CIDs a year, often part of a broader phishing expedition around a particular industry. Now, even though processors do their part to fight fraud through robust underwriting and monitoring, payment processors simply are not law enforcement. The fact is that sometimes processors miss red flags or make unintentional mistakes. But it's a big leap to suggest that a processor was intentionally aiding and abetting a merchant in fraud and should be left to cover the total cost of consumer injury caused by the merchant. And that's exactly what the Federal Trade Commission does. Specifically, the FTC seeks to hold payment processors and even individual owners and employees financially responsible for the total volume of sales transactions processed for a bad merchant, even where the processor made just a penny on the dollar for such transactions. Emboldened by a recent but misguided decision in the 11th Circuit, entitled Universal Processing, the FTC's aggressive use of joint and several liability threatens to put targeted processors out of business or even to bankrupt individuals based on the conduct of a single bad merchant out of a processor's entire portfolio. It's important to understand that the FTC uses the same aggressive tactics in all cases, even where a processor cooperates with the FTC to assist law enforcement activities. The FTC's insistence on joint and several liability for payment processors makes it financially impossible for a processor to try to defend itself in court. A small processor that earns a few $1,000s processing for a merchant can't take the risk of litigating a case where the FTC seeks to hold a processor liable for millions of dollars. When the FTC sends a CID to a processor regarding a merchant, it tells the processor to maintain confidentiality and to continue processing for the merchant. But then the FTC inevitably turns on the processor and seeks to hold it financially liable for all of the volume processed and all of the merchant's sales, including those after the CID was issued. Similarly, where a court appoints a receiver to manage a merchant's assets, the FTC pressures the receiver to take possession of a processor's reserves for the merchant, even though those reserve accounts belong to the processor, not the merchant. The processor is then forced to cover consumer chargebacks out of its own funds. The FTC refuses to discuss settlement of a case against a processor until the processor or its individual owner provides financial information. The FTC also engages in aggressive prosecution of individual officers and employees for assisting and facilitating the conduct of a merchant employee, even where they had no control over that conduct. And the FTC regularly uses its CID process to request information from third parties when that information is regularly available to the FTC itself. The result of this enforcement approach is that payment processors will have no choice but to increase prices for services to merchants and, even worse, restrict access to payment systems to certain categories of merchants to maintain or to avoid exposure for liability. There is, however, a better path forward. Congress should encourage the FTC to review and reconsider its overly aggressive use of CIDs and questionable discovery and enforcement tactics. Former FTC Chairman Olhausen in 2017 announced just such an effort. That effort should continue. Congress should include a provision in the FTC's budget authority limiting the FTC's ability to seek joint and several liability against payment processors, except where the processor is actually an active part of a common enterprise with merchants. Congress should direct the FTC to halt enforcement actions against processors until they engage in a public discussion of Operation Chokepoint. And Congress should support the FTC to encourage additional industry self-regulation. Thank you for the opportunity to appear here before you today, and I look forward to your questions.
Thank you, Mr. Oxman. Ms. Sanders, you're recognized for 5 minutes.
Thank you. Chairman DeSantis, Ranking Member Lynch, Chairman Meadows, Ranking Member Connolly, and members of the subcommittees. Thank you for inviting me to testify today. I am Lauren Saunders, Associate Director of the National Consumer Law Center, which works for economic justice for low-income and other vulnerable consumers across the United States. Fraud takes billions of dollars from people every year, often from seniors and other vulnerable communities. Fraud also imposes costs on businesses and many other people in the country. Fraudsters often do not act alone. Many fraudsters rely on payment processors to take money out of consumers' accounts. Responsible payment processors can stop fraud or make it more difficult. Unfortunately, a very few outliers sometimes willingly enable fraud. The FTC's cases against payment processors are part of its traditional bipartisan law enforcement work, unanimously supported by both Republican and Democratic chairs and commissioners. These cases go back over 2 decades and are independent of the Department of Justice's former Operation Chokepoint. For example, in 1996, under Chairman Steger, who was appointed by the first President Bush, the FTC sued Windward Marketing, which used remotely created checks to help a magazine subscription scam bill consumers of over $12 million. In 2007, under Chairman Majoras, appointed by the second President Bush, the FTC sued Your Money Access, which processed more than $200 million on behalf of numerous fraudulent telemarketers and internet-based merchants, accepting merchants with facially false sales scripts and ignoring extremely high return rates. More recently, last year, the FTC sued the payment processor iStream Financial Services for processing discount code transactions despite numerous fraud indicators, including recommendations from the iStream's sister bank, independent compliance auditors, and iStream's own compliance and risk officers that the processing relationship be terminated due to the high return rates and likelihood of fraud. The FTC's work has been approved by courts, as in the recent case against WV Universal Management, the credit card processor for a fraudulent credit card interest rate reduction scheme. The processor's president had personally approved merchant accounts despite several glaring red flags, including chargebacks so high that they came to the attention of MasterCard, which noted the potential fraud risk. The 11th Circuit Court of Appeals affirmed imposition of joint and several liability on the defendants, but only after observing that it was undisputed that Universal had violated the telemarketing sales rule by providing substantial assistance to the scammers despite knowing or consciously avoiding knowing about the fraud. The testimony from the Electronic Transaction Association today criticizes the FTC's use of joint and several liability, but does not attempt to defend the conduct of the processor in the Universal case. And indeed, as Mr. Smith pointed out, I haven't heard anybody criticizing the cases they have brought. These are not close cases. There is extensive evidence of complicity of the payment processors in the very few cases that they bring. The FTC targets bad apples and provides incentives for the industry to police itself, spurring efforts like those of the Electronic Transaction Association to help its members prevent fraud and make enforcement unnecessary in most cases. Vague and unsubstantiated claims have been made that the FTC may be targeting entire classes of legal businesses. But the evidence is that the FTC targets fraudulent activity, plain and simple. While I disagree with the characterizations of DOJ's Operation Chokepoint, there is a key difference between that operation and the FTC, and that is the FTC starts with the scammer and then, like any good investigator, follows the money. Most of FTC's 600 fraud cases do not have a companion case against a payment processor. But if the FTC finds evidence that a payment processor was a willing participant and enabler, it brings an enforcement action, which is especially important because consumers cannot do this kind of investigation on their own, and they rely on government to prevent this type of fraud. The FTC's fraud work is especially important today with growing problems of identity theft, data breaches, and online scams. Everyone, from individual consumers to legitimate businesses, benefits when fraudsters and their collaborators are held accountable. Thank you for inviting me to testify today. I would be happy to answer your questions.
Thank you all for your testimony, and the chair recognizes the gentleman from the 11th District of Virginia, my good friend, Mr. Conley, for his opening statement.
I thank the chair and I thank our witnesses for coming here today. A little late today because we had a vote, and we're going to have some more votes very shortly. 2 days ago, during a full committee hearing on election security in this very room, I made a motion for the Oversight and Government Reform Committee to subpoena the Office of the Director of National Intelligence to inform the committee and the public about the extent of the Russian threat to our country. That subpoena, unfortunately, was tabled by a vote of 17 to 15. This morning, 2 Oversight and Government Reform subcommittees are teaming up to discuss the urgent problem of Operation Chokepoint, a program that no longer exists and a program that the full committee conducted extensive oversight of 4 years and 2 chairmen ago. What is, one wonders, the urgent need for this hearing now, when the administration is under legal compulsion to reunite children that have been separated from their parents as part of the zero-tolerance policy at the border, when the deaths of perhaps as many as 4,600 U.S. citizens in Puerto Rico have been attributed to Hurricane Maria and the federal government's inadequate response to it, when the Secretary of Commerce apparently misled this committee on why a divisive question on citizenship was hastily added to the 2020 census, when a member of this committee, full committee, forthrightly wrote an op-ed in the New York Times saying that the President of the United States has been manipulated by Vladimir Putin. These are all worthy of committee examination and open hearings. So what could possibly be the reason for this hearing today? Congress conducted lengthy oversight of Operation Checkpoint in 2013 and 2014. Congressional Republicans then alleged that DOJ and the FDIC intentionally conspired, to mislead Congress about their partnership and inappropriately targeted a list of high-risk merchants and industries to conduct Operation Chokepoint. The Committees on Financial Services and Judiciary also held oversight hearings. The Oversight and Government Reform Committee conducted an investigation under then-Chairman Darrell Issa that produced not one but two staff reports. Republicans got what they wanted. The two principal agencies involved in Chokepoint, DOJ and the FDIC, have both ended their work in the operation. The FDIC ended its involvement in Operation Chokepoint in January of 2015. The DOJ issued a letter to the chairman of the House Judiciary Committee in August that stated, and I quote, "All the department's bank investigations conducted as part of Operation Chokepoint are now over. The initiative is no longer in effect, and it will not be undertaken again," unquote. Pretty definitive. Yet here we are, questioning the Federal Trade Commission, an agency that played no role in Operation Chokepoint. And here we are because the FTC has a broad mandate to protect consumers from unfair, deceptive, or fraudulent practices in the marketplace. Some have concluded that this must mean a continuation of Operation Chokepoint. That, it seems to me, is not the case. As part of its work to protect consumers, the FTC works to stop payment fraud, including taking action against payment processors that knowingly or recklessly facilitate fraud. That's their job. The FTC's cases against payment processors goes back 2 decades and is not related to Operation Chokepoint, which started much later and, as we've heard, no longer exists. Enforcement action against payment processors who knowingly participate in fraudulent schemes or willfully ignore signs of illegal activity has historically received bipartisan support. These schemes often prey on vulnerable populations, such as seniors, immigrants with limited English language, or families of active duty military. According to a survey by TrueLink, a company that provides account monitoring software for elders and families, projected that financial elder abuse costs families more than $36 billion a year, of which $17 billion is linked to exploitation and scams such as work-from-home schemes, misleading financial advice, or reverse mortgages. I can't speak for my colleagues, but I have to say, we ought to be having hearings, it seems to me, about some of the pressing issues of the day. And we could start with the list of subpoena requests that Democrats have submitted to the full committee and the full chairman. I think there are now 62 of them outstanding. That would be some work worthy of our enterprise. I thank my friend from North Carolina for letting me have this time for my opening statement, and will try my best to participate before we call votes.
Well, I thank the gentleman from Virginia, and as he well knows, on some of those items, I'm willing to advocate in a bipartisan fashion to deal with some of those. I would like to note, ask unanimous consent that my opening statement be made part of the record without doing it. Any objection?
No objection.
Yeah, all right, so ordered. Also, I'd like to recognize Charlie Kirk, who's here. Thank you for being here. You've done some work on this particular issue, and we appreciate your work. And so with that, I'll recognize the gentleman from Florida, Chairman DeSantis.
Thank you, Mr. Chairman. Thanks to witnesses. I appreciate the work that you guys do, Mr. Smith. There's a lot. Fraud is just the cottage industry, particularly my state of Florida. You know, you have seniors, and I think we're by far, I think, the #1 state for complaints. So I think it's very, very important. And the issues you cite where people are knowingly involved in fraud, I think that's a no-brainer. How would you respond to Mr. Oxman? Because there seems to be a a discrepancy here about how innocent processors are treated by the FTC. Because I would say if the people who are committing the fraud, that's where you would want to do the government action. If people are simply processing this stuff without being a part of it, then putting some of these investigative demands on them raises the cost of doing business, and that hurts consumers too, because people don't have access to the ability to do that. So how would you respond to some of the things Mr. Oxman pointed out?
Right. So in the 15 cases that we brought, I don't think there's any disagreement about complicity by the payment processor. So there are issues raised by Mr. Oxman about what I understand to be compulsory process issued by the FTC to payment processors as a part of a broader investigation. So we do this kind of third-party discovery like any litigant does and like any law enforcement agency does. We do it routinely. We send third-party CIDs, civil investigative demands, to telephone companies, to banks, to payment processors, to internet registrars in order to gather information for our investigations of fraudsters.
Is there a threshold that's required before you initiate that?
So any CID that we issue, whether it's to a target or to a third party, has to be approved by a commissioner, and it has to articulate specific allegations of a law violation in order for us to issue the CID. So we can't do fishing expeditions to, we want to investigate the business opportunity industry, and so this CID, we're sending it to 100 companies as a part of that. We don't do that because we're not permitted to do that under our rules of practice and our statute. So we do send third-party process, though. All law enforcement agencies do, and we're sensitive to the fact that it's expensive to respond, and we appreciate that. And as Mr. Oxman noted, in 2017, the FTC undertook an effort to streamline its CID processes to make them more manageable for businesses. But the fact remains that we really need to get this information from third parties. We frequently can't get it anyplace else, either because the investigation is confidential and we don't want to tip the target, or because we get better information from third parties than we get from the target. We have frequently found instances where, remember, we're talking about fraudsters here, where they have given us bad responses to our CIDs, and we've gotten better information from third parties. But we understand and respect that that presents an expense for legitimate businesses, and we appreciate that and try to factor that into our targeting.
The idea of holding the person processing the transaction responsible for the entire amount of transaction, unless there's evidence that they knowingly were participating in the fraud, that would not be something that you would support?
Right. So in the 11th Circuit case that was mentioned by Ms. Saunders, the court held that, and there are a couple of other court decisions that have similar holdings, that in order to impose joint and several liability on a payment processor, the FTC has to show that they knew of the fraudulent scheme or they consciously avoided knowing it, and they actively facilitated the fraudulent scheme. So in that 11th Circuit case, what happened was that the company president was complicit in sort of fast-tracking these fraudulent transactions through circumventing the underwriting process and the monitoring process. And the company essentially admitted liability. The question was there enough knowledge, was there enough intent in order to satisfy that joint and several standard? And the court held that there was.
So, Mr. Oxman, how would you respond? Because I think that Mr. Smith's saying, hey, there are rare instances where there's active participation. And look, I mean, that's a totally different issue. If they're actively engaged in fraud, you are raising concerns about kind of just the normal course of business and having government action really hurt the industry. So how would you respond to what Mr. Smith has said?
That's exactly right. And I think the reason that both Mr. Smith and Ms. Saunders focus on those 15 cases is we have no dispute with those cases, and we're not here to discuss that. What we're here to discuss and what we're raising concerns about is what's happening at the FTC in all the cases we don't know about. So our member companies are telling us that there are an unrelenting number of CIDs coming out of the FTC in cases where the commission appears to be looking, I call it a fishing expedition, at particular merchant categories. They're sending these CIDs out, sometimes dozens at a time, looking blanketly across multiple industries and using the information gathered to build cases. And as Mr. Smith noted, those CIDs don't need the approval of the entire commission. They need one commissioner. And what we're looking for is a process where as in those 15 cases, the entire commission is making sure that these actions are justified and that the burden is not placed on processors to take these actions in support of law enforcement where they are legitimately going against bad merchants. That's the concern that we have.
Great. I'm out of time, so I'll yield back.
The chair recognizes the gentleman from Virginia, Mr. Conley.
Thank you, Mr. Chairman. At this time, I would defer to my colleague, the brilliant gentlelady from New York.
Thank you so much, Ranking Member and Chairman, for holding this important hearing on consumers and protection for them. I want to commend and thank Ms. Sanders and the organization she represents, the National Consumer Law Center, for the initiatives that you've taken to protect disadvantaged people, poor people, and particularly elderly people from financial scams. So first I'd like to ask you, in your own words, at the NCLC, what types of financial scams targeting the poor, the elderly, or other vulnerable people have you seen and come across? We can't hear you.
The variation is really incredible. We see a lot of grandparent scams. In fact, my own father was subject to one of these that the FTC actually did a little profile blog on. Somebody called up, and my father, who is very competent, 88 years old, but he got a call, hi, this is Ben, and I've been arrested, and I need some money to get out of bail. And even my own father, who, thought that didn't sound like his voice, called me up and said, where is Ben? And, he was very scared, and the scammer wanted him to go and send him money.
Wow.
We see romance scams. We see lottery scams. We see fake credit card reduction scams. And often these scams do target seniors and people with limited English proficiency and other IRS scams. I get these calls all the time. I'm the IRS, I'm going to arrest you. Now, I don't know the IRS, so I'm not too scared when I get those calls. But there are, people who have trouble with their back taxes, don't realize it's not the IRS on the other end. There are all sorts of scams, and a lot of these scams require a method to take the money from consumers, to take the money out of their pockets, and most payment processors have, do their best to stop being willing participants, but those who do are appropriately subject to enforcement, and the FTC needs to investigate to figure out who is culpable and who's not.
Okay, you've given some examples of people. Could you give some examples of how the FTC is important in protecting consumers against predatory third-party payer processors, which Mr. Oxman seemed to feel are being unfairly targeted?
Right. Well, I mentioned the iStream Financial Services case. This is a case where people were signed up for discount clubs that they really didn't want, and money was taken out of their bank account. And
they signed them up without their knowledge and then took the money out of their account?
Exactly. I mean, often,
how in the world can you do that? Isn't the bank there to, how could they get into their accounts?
Because people often provide their information because they think they're signing up for something else. They may think they're signing up for a payday loan. They may think that they are getting a one-time, purchase of something. But once they have their bank account information, they can use that maybe sometimes in the fine print in deceptive terms. They sign them up for something else.
Is this usual that payment processors participate in scams like this?
Payment processors are often essential to move the money in order to take a credit card, a debit card, to do an electronic payment. Now, again, they aren't all complicit, but they are often a key part of how the scam works and how the money gets from the consumer to the scammer.
Now, what would happen if consumers were helpless, if there was no FTC there to help them in payment scams or other scams? I talked to some of the prosecutors in New York, and they say a lot of their work in the district attorney's office is just trying to protect people from scams all the time.
Right,
so,
absolutely.
But if you didn't have the FTC, would there be any protection for consumers in this area?
Consumers do have some protection against unauthorized charges, and they can go to their bank if they can show that the charge is unauthorized. And it actually imposes costs on banks as well, especially small banks. They're the ones who end up having to deal with these things, and it costs them money to have to deal with the consumer and reverse the charge. And sometimes they can't get them reversed.
Now, I want to get to some of the other witnesses. Mr. Smith, how many enforcement actions has the FTC pursued since 1996, and how many of these enforcement actions have involved a third-party processing payment system?
Right. So we looked back to 10 years to 2008, and we counted up 639 enforcement actions. We decided just to focus on the last 10 years because it would have taken us a lot of time to count up until 1996. But we have, in that 10 years, we have 639 enforcement actions generally and 15 against payment processors. And one quick thing I wanted to add is that we are focusing a lot on the complicit payment processors, but the payment processing industry, trillions of dollars of transactions happen without event, right? So consumers should feel safe that the payment processing industry is looking after their best interests. It's just in these very few cases where we've found need to drill down and hold the payment processor responsible.
May I just, Mr. Chairman, ask a question related to what he just said?
Very succinctly.
Okay.
Very succinctly.
Okay, so what is the estimated amount of financial harm consumers have suffered in these 639 cases and 15 with, so we get a sense of what is the economic impact on on people and the economy?
Right. So you can answer briefly. Gentlewoman's time's
In the
expired.
15 cases, we had $700 million of harm, and we recovered $620 million for consumers.
Wow.
Okay. Chair recognizes the gentleman from Georgia.
Thank you, Mr. Chairman. Mr. Smith, what was the role of the FTC in developing Operation Checkpoint?
So I wasn't at the commission at the time, but I have spent a lot of time reviewing the OGR prior investigations, and I've also spent a lot of time talking to staff. And the FTC was a part of the Financial Fraud Enforcement Task Force established by President Obama, and along with something like 30 other agencies, Securities and Exchange Commission, IRS, et cetera. We also were a leader of the Consumer Protection Working Group of that FFETF, and as the nation's primary consumer protection agency, that would only make sense. And there were maybe another dozen agencies on the Consumer Protection Working Group. So we communicated with DOJ and all of our law enforcement partners regularly about fraud cases. In terms of specific Operation Chokepoint activity, the FTC, as I understand it, wasn't involved in that. It wasn't involved in targeting, to the extent that there was any, of particular industries. But I don't want to say that there wasn't information being exchanged by the FTC with its law enforcement partners, because we do that all the time pursuant to our rules and approval by our general counsel.
Right. According to memos about Checkpoint, as I understand it, the FTC provided the DOJ with potential leads for Operation Checkpoint investigations.
Well, we provided the DOJ with names of banks.
Right.
Don't know if that was for Chokepoint or for something else. One thing that's important to remember is that the FTC doesn't have any jurisdiction over banks. That's specifically carved out from our statute. DOJ does. So to the extent that there might be banks that have information or that may be problematic, then that's a DOJ.
But as you came up with suspicious information, that information was passed on as a potential lead, according to memos, as I understand it. So my question from that would be, how would the FTC determine a particular company's or institution whether or not they should be investigated? What are they looking for?
So a particular company, we were looking for strong evidence of fraud, and we would investigate the merchant, right? So we would investigate the business opportunity scam or the robocalling scam. And in the course of that investigation, as Ms. Saunders said, we follow the money, as all investigators do. So you go to the payment processor, you go to the acquiring bank, you go also to other third parties like the telephone company and the internet registrar to gather up information. And so in the course of those investigations, there is a process between the FTC and other law enforcers to share information that we gain.
So did FTC actually participate in Operation Checkpoint?
No, not as far as I know. I mean, so if you think of Chokepoint as these, it was defined earlier in the hearing as these 60 subpoenas that were sent out, that's not us.
All right. Now, before your appointment to FTC, you worked for a law firm that represented companies against Operation Chokepoint. Is that correct?
Yes.
Okay. what were, I'm curious of some of your experiences with that. Did any of your clients have assets seized as a result of Operation Chokepoint?
So my involvement with Operation Chokepoint, and this is a matter of public record, I was a partner at the law firm of Covington and Burling, and I represented a trade association for online lenders who were impacted negatively by Operation Chokepoint. So the work was primarily on a policy level, working with the agencies to determine how we can resolve Operation Chokepoint, because the problem was that legitimate companies were losing their banking relationship.
Right, that's what I'm aware of. So,
Right.
so with that, and that was a whole problem with this. So I take it that you did represent some companies that had some assets seized.
No, not so much companies, but more this trade association.
Okay,
So I don't know if
where's the seizures justified?
I don't know of any asset seizures for Operation Chokepoint. The problem was the loss of the banking relationship.
You don't know of any seizures as a result of, because I certainly do.
Of Operation Chokepoint, no. I mean, I know that the FTC and in the course of our law enforcement, we will seize assets in order to return money to consumers. As far as Operation Chokepoint is concerned, so at the top of the hearing, it was defined as the 60 subpoenas resulting in 3 actions against banks. And as far as asset seizures, that I don't know. I think the banks were exposed to penalties, perhaps for anti-money laundering issues, but I don't.
Well, so were companies, and unfortunately my time has expired, Mr. Chairman, so I'll yield back.
I thank the gentleman from Georgia. The gentleman from Virginia is recognized.
Thank you. Ms. Saunders, I understand from your testimony, you certainly believe in this context, consumers need some protection.
Absolutely.
You need to speak closer to that microphone. You could bring it close. You can bring it, move it to you. Okay.
Okay. Yes, absolutely. I think fraud would be far, far worse if we didn't have the FTC and other law enforcement agencies, looking at this fraud and finding everybody who is culpable.
Right. Now, one of the practices that's concerned me for a long time, certain payday lenders, for example, not all, but some, prey on vulnerable families of active duty military, especially those who are kind of shipped overseas and their families are left behind. They tend to be lower income folks, and making ends meet can be a real challenge. Is that a problem in your experience?
Well, the Military Lending Act today does prohibit high-cost loans to service members. Certainly, payday loans have been a problem with service members and their families and loved ones. That's not anything related at all to, the FTC's enforcement work against payment processors. But separately, we have pushed for protections for service members and all families against predatory lending, and payday lenders are a big problem.
Yeah. I guess the point I was just trying to make is that when we look at sort of financial predation, it covers all kinds of classes of people: seniors, ordinary consumers, and even our active duty military families who can be taken advantage of in times of need. And they all need some place to go for protection.
Right, absolutely. And certainly service members and veterans are targets of fraud, like any other American, and they need the vigorous work of government to stop those kinds of scams and to cut off these scammers from the ability to take money as long as we are going after the payment processors who are willing participants.
Right. Now, you gave the example of your dad.
Mm-hmm. Who's a veteran.
I'm sorry?
Who is a veteran.
Who is a veteran, served this country. I think all of us know stories of sort of the unwitting compliance, unwitting in that people are sometimes too trusting or don't have their guards up. And none of us want to sort of become, jaundiced and cynical as a society, but on the other hand, trying to help folks who maybe are more vulnerable to those kinds of schemes and threats and manipulation. And I mentioned that the best estimate we had was that elder crime in this kind of category was $36 billion a year. Sound right to you?
I've heard that number, yes.
So do you want to expand just a little bit in terms of why senior citizens are maybe more vulnerable than some others in society and more susceptible to this kind of consumer fraud?
Right. Well, seniors, are often more trusting. Those of us here in Washington tend to be very cynical, but they do tend to be more trusting.
Not on this committee, Ms. Saunders.
Okay.
Yeah.
They are often lonely, and somebody who calls them on the phone and is friendly and talks to them, can be very persuasive. I have an uncle who was subject to a romance scam, and I could not convince him that this woman, who he was so lonely, and this younger woman befriended him, I could not convince him that even after he wrote $30,000 worth of checks to her, that she was a scammer. I could not convince him to go to the police. He was later subject to identity theft as part of the same, problem.
Yeah.
And I had to go to the number of banks who were innocent, who had fraudulent accounts created there, but I had to enlist their help.
To what extent are some of these fraudsters offshore, overseas? And does that complicate our ability to regulate that?
It does. I mean, they are often in boiler rooms offshore, and sometimes the money is moved offshore. That's why our anti-money laundering laws and know your customer rules are especially important to stop this kind of fraud and other movements of money overseas.
Yeah, I think that's really important to note as well, because I know of one in particular headquartered in the Caribbean, and that scheme was to call you up and say, you've won the lottery, the Jamaican lottery or whatever lottery, and all you have to do is send us, your credit card number and $200 and for processing, and you're going to be rich. Yeah. And I couldn't believe how many people, unfortunately, were prey to that scheme. So that's a whole different dimension. Thank you, Mr. Chairman.
The gentleman from Kentucky is recognized, Mr. Massey.
Thank you, Mr. Chairman. Mr. Smith, in 2011, the FDIC Quarterly Journal published a list of 30 merchant categories that were high-risk endeavors. Among these categories included what I consider to be very legitimate commerce: ammunition sales, firearm sales, pharmaceutical sales, surveillance equipment, and tobacco sales. Does the FTC use this list, or does the FTC have their own list of high-risk categories? And is that publicly available?
We don't have a list of high-risk merchants. We don't target our enforcement activity based on high-risk merchants. I will tell you, in all of the cases that we've brought that we outlined here, the fraud cases where there have been payment processors involved telemarketing boiler rooms, essentially, real hardened scams, situations where merchants were debiting consumers' accounts without even any authorization.
Okay.
Essentially
I just want to make sure you weren't targeting firearm sales, ammunition sales, pharmaceutical sales.
No, none of our cases have been brought again. I mean,
I'm not talking about the cases that have been brought, but the things that are initiated and the way you look for cases.
Right. We don't. Okay. So in terms of case targeting, we look at things like consumer complaints, consumers who have been defrauded. We conduct consumer surveys to determine whether or not there are companies that are engaged essentially in deceptive conduct.
Okay.
So that's our.
When you think you found it, do you have a standard formula to fine or penalize processing companies, or does this sort of ad hoc, make it up as you go?
Well, we're looking for complicit evidence that these processors were complicit in the underlying fraud. Mm-hmm. And typically in fact, in every case that I reviewed in preparing for this testimony, in every case we have a situation where the payment processor was actively hiding the misconduct from its banking partner.
But I'm assuming you found somebody who's guilty of something. Do you have a standard formula for the penalty?
So when with respect to the underlying merchant, we look for unfair or deceptive conduct. Okay, so our cases, we start with the underlying merchant, and we typically prove up or allege fraud, get a settlement sometimes with that merchant. So real fraud, deceptive conduct that hurts consumers. And then we follow the money, and in those couple of cases where we've thought that the payment processor went sort of beyond the pale. I mean, we're not pushing the envelope here. We're talking about really bad conduct by payment processors. In those cases, we've brought action.
But my question is there a standard policy that guides when you're going to do that, or what the penalty is going to be?
We don't have a written policy for when we bring.
My next question is, I heard you say, I think, and this is encouraging, that you acknowledge that the civil investigative demands are a burden on the merchants, or the
on all third-party recipients. So the payment processors aren't unique in this regard, or uniquely burdened. But any company, we routinely, in the course of our investigations, and this is true for all law enforcement agencies, state, federal, local, we will have to seek information from third parties unconnected from the fraud. And responding to that compulsory process is going to be expensive, and we understand that and appreciate it, and do our best to minimize.
It's almost like a tax, this added regulatory compliance. So given that, I think it's important to know how many of these CIDs have been initiated. Can you tell us, I think Mr. Oxman has alluded to an increased amount or activity of CIDs. Can you give us the number of CIDs?
I don't have the number of third-party CIDs that we've.
Are they going up or down, or?
My guess is that they're going to be flat, because I think that our enforcement activity is generally, fairly steady pace. So as an example, if you just look at
instead of guessing, could you just give us those numbers, like how many CIDs? Could you give us that later? I'm not asking for it today.
We'll talk. I'll ask the staff if we can get those numbers.
Thank you. I got one last question in the last 30 seconds. I'm glad to hear that you've recovered money for people who've been defrauded, but can you guarantee us that all of the assets that are seized by the FTC go to victims or consumers, that none of it gets diverted to other things?
Well, there are severe legal limitations on our ability to divert money.
So it never happens?
So there are cases where we're administering a redress program, and there's money left over, and in those cases, sometimes.
So you've remunerated all of the victims, and they've all become whole, and you've got money left over?
Sometimes, because not every victim.
Every victim has always been compensated?
We can't always find every victim, but what I'm talking about here is a small amount of money, typically in the tens of thousands, and we disgorge that to the Treasury Department.
So
because it's very
do you know what they do with it? Just goes back in the general fund?
It goes into the general fund.
So it's not diverted to any type of projects or anything?
We're prohibited from that. I think it's called the Miscellaneous Receipts Act, and we're prohibited from using money that we recover for consumers for our own purposes.
All right. My time has expired. Thank you, Mr. Chairman.
I thank the gentleman for his insightful questions. The gentleman from Kentucky, Mr. Comer, is recognized.
Thank you, Mr. Chairman. I have two questions for Mr. Smith. First of all, has the Federal Trade Commission performed any studies or research on whether holding processors responsible for all the alleged harm caused by a merchant will result in higher processing costs for merchants and ultimately consumers?
Well, so first, I disagree with the premise that we're holding all processors liable for all fraud. We're bringing, as we've said a couple of times, very few cases here. But in answer to your question, no, we haven't conducted a study.
Does the FTC have a standard approach to settlement?
To settlement with payment processors?
To settlements.
To settlement.
Yeah.
So most of the cases that we bring, we settle, particularly in the fraud area. In some cases, the bad guys don't show up for court, and so we get a default judgment. And in the course of following the money to try to return money to consumers, if we go to a payment processor, then most of those cases are settled too. Of the however many that I mentioned, I think 4 have been litigated.
What are ways in which the FTC can improve its tactics to be less burdensome to law-abiding and legitimate businesses?
Well, we have, last year, the Commission undertook an effort to streamline its CID process, and we've heard back from industry that that's helpful. Of course, more always needs to be done, and we're open to additional suggestions about how to streamline the process. Then the other aspect of that would just be to send fewer third-party CIDs and try to get information from the targets themselves. We sometimes have difficulty doing that because the investigation is confidential or because the targets aren't forthcoming, so we have to go to third parties. But we appreciate that this imposes a burden on businesses, and we are always looking for ways to lessen that burden. Having said that, we badly need this information for our law enforcement program. We badly need information from third parties, whether it's payment processors, banks, telephone companies, internet registrars, other folks who provide services to the companies that are defrauding consumers.
Thank you, Mr. Chairman. I yield back.
I thank the gentleman. The chair recognizes himself for a series of questions. Ms. Saunders, listen, I think all of us up here want to make sure that consumers are protected, and the horrible stories you hear, actually, I've been one that, it's interesting because occasionally I get these phone calls where I've won unbelievable amounts of money, and they just want me to call back, and so I do. And it's very interesting when we have these dialogues with a member of Congress, and so I've called the FTC. So we want to protect it, and so I want to say thank you for being an advocate for those consumers. But there is an equal protection that has a concern as a business guy, as a small business guy. And Mr. Smith, you've talked about only bringing a few small actions. But is it not true that you many times will freeze assets and force companies to settle without ever bringing them to trial?
So I think you're talking here about the issue.
Well, you cast a wide net, so you get a complaint. You cast a very wide net and literally freeze their assets, so they don't have the ability to actually endure long term because you don't bring the case. Actually, you don't ever bring the case, but they holler, "Ollie, Ollie, Oxenfree, please let me go," and so they settle the case.
We don't have the ability to freeze assets without a court order. So here's how an asset freeze would work. And typically we would
but the power of the FTC is well known, and so you get a court order and you've cast a very wide net. Do you not cast a wide net?
So we get a court order against the bad guy.
Right.
Temporary restraining order.
And everybody that touches the bad guy.
And a receiver appointed. No, the money of the bad guy, right? So we find the bad guy's accounts, or more appropriately, the receiver finds the bad guy's accounts and freezes them. It's the receiver's job, who's appointed by the court. And within those accounts, when those accounts are held by other people, then what the law says is that a constructive trust is established over that money because it's money that is being held for the merchant by its service providers. And so the receiver may reach out to those other accounts that are being held on behalf of the merchant by others.
So, Mr. Oxman, maybe help clarify my question so Mr. Smith can understand it a little bit better.
Yeah, thanks, Mr. Chairman. So this enforcement strategy that Mr. Smith calls follow the money, here's how it works. So they'll go after a legitimate fraudster, and as you noted, Mr. Chairman, it's very important that they do so. It's an important law enforcement function. Once they've established a case against the fraudster, a bad merchant, they then turn their sights on the payment processor and say, okay, you processed $40 million in transactions for this merchant. They were bad, so we're going to go after $40 million of your money. And the processor says, well, wait a minute, I only made $5,000 off that, less than a penny on the dollar from that transaction. And the FTC says, well, no, you processed that money for them, and you have a reserve account, which, by the way, is a reserve account
to pay this.
To pay consumers.
Right.
Chargebacks, they're called.
Right.
And instead of allowing the processor to take those funds and reimburse consumers, the FTC says, or directs a receiver to say, no, we're going to seize that money, we're going to use it. That's the follow the money strategy. And as you noted, Mr. Chairman, that strategy punishes processors who weren't even implicated in the process at all. It's like holding a cash register responsible for taking money and going after the manufacturer of the cash register, or holding AT&T responsible if you and I have a phone call plotting a crime. Going after the processor might seem easy because that's where the money is. But when you're following the money to a party that had nothing to do with the fraud, that's where the problem comes, and that's where the issue of payment processors, having to shut off merchants unfairly, having to raise their prices because of this FTC enforcement strategy. So what we'd like to see the FTC do is follow the money to the fraudster, don't bring in innocent parties like payment processors and hold them financially responsible, essentially as an insurer for bad merchant behavior.
This is not an issue of holding payment processors liable for the full amount of the fraud. This is an issue of marshaling the assets of the fraudster and freezing them. So these reserve accounts are.
So you're saying what he just said, freezing the $40 million. In his example, he's
We're not freezing $40 million.
Well,
The
hold
reserve
on.
accounts don't have the full amount of the fraud in them. The reserve accounts have whatever the payments that the
So
that the
are you
payment
saying that there's
processor is
not
holding
enough
back.
money in the reserve accounts to pay the consumers? Is that your sworn testimony here today?
What I'm saying is that
No, I just, yes or no. Is there enough money in the reserve accounts, like Mr. Oxman said, if you had the reserve account that would actually go to her father or whomever if it was done improperly? Is there enough money in the reserve accounts?
there's never enough money in the reserve accounts because it represents a fraction of the fraud. It's just whatever money the payment processor is holding back for the last 60, 90, 180 days, whatever the contract is between the payment processor and the merchant.
Okay, so why then, if it's frozen, why would you freeze that?
We would freeze it.
Freeze the reserve.
We would freeze the reserve account so that we can marshal all of the assets of the fraudster and make as close to full recompense as we can.
So let's
to all of the
assume that
customers.
you're following the money, and the FTC follows the money, and you freeze the assets. What happens when they're innocent?
Well, we're not freezing the assets of anyone who's innocent. We're freezing the assets of the fraudster that are being held.
So how do you know
by
that
the
they're guilty?
processor. I'm sorry?
How do you know that they're guilty?
Because a court has.
Well, you got a
entered
court
temporary
order. That's
restraining
different
order.
than having an actual
Well,
case.
no, we have to make a strong showing to the court. Look, a TRO, an asset freeze,
Right,
the appointment of
okay.
a receiver, these are extraordinary remedies, and courts don't enter them lightly. We go into court without giving an opportunity for the other side to respond because the fear is that if we do, the money, the evidence, the people will be.
Okay, that makes sense. That makes sense. So here's what I would ask of you, Mr. Smith, because you've got a long career, not just in your new job, but at the FTC. And actually, I have found the people at the FTC to be very capable federal servants. I mean, they actually are great, a great group. I actually, when I was a freshman, had a hearing with the FTC and found the engagement to be delightful. Here's the concern that we're hearing. So just as awful as some of the stories that Ms. Saunders has shared with us, we're hearing some stories from people who believe that they've had a disproportionate amount of attention based on through no fault of their own. And so it'd be like me processing something, and all of a sudden I find that I processed through millions of different people. I had one bad actor, and then all of a sudden my entire business operation gets constrained. And we've got to find a way to deal with that too, because what happens, and whether it's additional reserves, whether it's actually looking at a more targeted approach, because if we're not dealing with that, Mr. Smith, what we're doing is we're having a chilling effect on a number of different small businesses. And as a small business guy, that's something that I'm not going to stand for. And so I can tell by the way you're nodding that you're willing to help us work through this. This is not my issue. This is not one that honestly, when I heard about it originally, I said, well, how could that be going on? If you're willing to come in and brief, our staff or me personally, I'm willing to look at that. And I think as a small business guy, hopefully what I can do is help mediate the distance between Mr. Oxman, Ms. Saunders, and you, Mr. Smith, where we can come together and say, well, this is some good policy that we can change, and figure out what part is legislative and what part of it is administrative. Does that sound fair?
Yes, and I would add that in most instances where we're talking about reserve accounts, that there is some sort of an accommodation that's agreed to by the parties. The ultimate issue over whether the receiver owns the reserve accounts is one for the court, but it doesn't usually get there, and we're able to reach some sort of an accommodation.
So let me tell you what you may be getting a little bit of side benefit. Obviously, Operation Choke Point was an issue that had a political agenda in some shape or fashion. The other part that you're getting from me is seeing the FDIC do similar things when it comes to banking regulations and what they do. And so you may be getting a little bit of spillover, because I have seen the long arm of the FDIC at times do things that have an unbelievable chilling effect that make absolutely no business sense whatsoever in the name of protecting consumers. And so I want to be fair to you. And so if I see some of your staff nodding that they're willing to come in, so I assume that you're willing to bring your staff in to help where we can work through that. And Mr. Oxman, I would ask you give me a few more examples. Ms. Saunders, if you will do the same from a consumer standpoint, hopefully we can come together and we can fix this without another hearing. How about that? Does that sound good?
We'd be happy to work with your.
All right. And so, with that, I'd like to thank all of you for appearing today. I think they're, well, they did call votes, and so hopefully I'll make it. The hearing record will remain open for the next 2 weeks for any member who wants to submit an opening statement or questions, so you may get follow-up questions from some of those members. If there's no further business before the subcommittees, it stands adjourned.
Thank you.